Welcome to Immigration Quicktake. This is Ellie Rutledge Silver with the American Immigration Lawyers Association. Last night, the U.S. Fifth Circuit Court of Appeals denied the federal government's appeal of the preliminary injunction that has temporarily stopped President Obama from implementing his latest deferred action initiatives. Here to discuss the decision and next steps is Melissa Crow, Legal Director at the American Immigration Council. Melissa, thanks for joining me. What did the decision say?
Ellie, as the dissent notes, the Fifth Circuit essentially affirmed the finding of the district court, carte blanche. First, the majority found that Texas had standing to bring this case on the basis of its alleged injury due to the additional costs that it would incur for having to pay for driver's licenses for beneficiaries of DACA Plus and DAPA. Secondly, it found that the plaintiff states had a substantial likelihood of prevailing on the merits. The district court had found only that the procedural claim under the Administrative Procedure Act was meritorious. In other words, that the U.S. government should have gone through notice and comment rulemaking before promulgating DACA Plus and DAPA. But that conclusion is fundamentally flawed because the issue turns on whether the decisions under these two initiatives are discretionary. And we think that there's no question that they are, and the dissent confirms that conclusion quite eloquently. DACA Plus and DAPA are very much like other executive action programs that have been implemented by every administration since Eisenhower, going back to 1956. Now, the Fifth Circuit went one step further than the district court by finding that the plaintiffs also had a substantial likelihood of prevailing on their substantive claim under the Administrative Procedure Act. And this finding is essentially that the U.S. government exceeded its authority under the Immigration and Nationality Act. And for much the same reason, this conclusion is flawed as well.
What did the dissent focus on?
The dissenting opinion was beautifully reasoned, and Judge King essentially points out that if the decision of the Fifth Circuit were to be affirmed, it would set a very dangerous precedent for states to be able to question a broad spectrum of federal policy decisions where they really don't belong. She also explained at some length why determinations under both DACA Plus and DAPA are inherently discretionary, and why Texas's alleged injury under these programs is tenuous at best. Texas itself has made a decision to subsidize driver's licenses for anyone who resides in that state, and it could very well change its mind about whether to do that. But the prospects of states being able to file a lawsuit like this and change the tide of federal immigration policy is something we've just never seen before now.
The Department of Justice announced today it will be seeking review from the Supreme Court. Do you think that the Supreme Court will take this case up?
I think that's anyone's guess, but I think it is really a perfect decision for the Supreme Court to get involved in. It involves a fundamental disagreement among states on a question, a quintessentially important question of federal policy. Arguably, there's a circuit split, given that the D.C. Circuit came down the other way in the case that Arpaio filed against President Obama, and it implicates really fundamental questions of the separation of powers between the federal government and the states, and the impact of this decision on the lives of up to 5 million people is quite significant. So fingers are crossed, but my hope is yes.
Thanks, Melissa, for joining me. For the rest of you, please stay tuned for more updates from the American Immigration Lawyers Association.